Good morning, everyone. Today, I will provide an overview and some legislative updates of the new inspection regime. The focus will be on Phase 2, which will commence operation next month on the 24th of October. First of all, let me introduce some background information about the new inspection regime. Currently, the company's register kept by the company's registry contains personal information which is available for public inspection. The personal information includes the usual residential addresses, URAs, of directors, and full identification numbers, the full IDNs of directors, company secretaries, and other individuals, such as liquidators. The relevant provisions of the company's ordinance concerning the new inspection regime were actually not new. They were passed by the Legislative Council in July 2012, but the provisions have not fully commenced. The provisions were made with a view to enhancing protection of personal information while keeping up the transparency and usefulness of the company's register by allowing the public to continue inspecting the company's register for the purpose of making the relevant provisions about the new inspection regime under the company's ordinance. The provisions actually were made with a view to enhancing protection of personal information while keeping up the transparency and usefulness of the company's register by allowing the public to continue inspecting the company's register for the purposes under the CO. In recent years, there has been rising concern in the community over whether personal information contained in public registers are adequately protected, especially in light of the increased personal data misuse. The government has reviewed the situation and considered it's appropriate to implement the new inspection regime. For this reason, 7 pieces of subsidiary legislation have been made to implement the new inspection regime in 3 phases. Under Phase 1, which commenced operation on the 23rd of August 2021, company may replace URAs of directors with their correspondence addresses and also replace full IDNs of directors and company secretaries on their own registers for public inspection. Under Phase 2, which will commence operation on the 24th of October this year, protected information on the index of directors on the company's register will be replaced with correspondence addresses and partial IDNs for public inspection. Protected information filed in documents for registration after commencement of Phase 2 will not be provided for public inspection. On the other hand, specified persons could apply to us for access to protected information. For Phase 3, data subjects could apply to us for protecting from public inspection their protected information contained in documents registered with the company's registry, and replace such information with their correspondence addresses and partial IDNs. Similar to Phase 2, specified persons could apply to us for access to such information. Phase 3 will take effect from the 27th of December 2023. So what is protected information? According to Section 54, subsection 2 of the company's ordinance, protected information means an address contained as the usual residential address of a director, or a number contained as the full number of the identity card or passport of any person in any part of the document that is required by the CO or the company's Winding Up and Miscellaneous Provisions Ordinance, that is CAP 32, to contain that usual residential address or that full number. As I've mentioned earlier, upon commencement of Phase 2 of the new inspection regime, specified persons could apply to us for access to protected information. So who are the specified persons? According to Section 12, subsection 1 of the Company's Residential Addresses and Identification Numbers Regulation, CAP 622N, specified persons include a data subject, a person authorized in writing by a data subject to obtain the information, a member of the company, a liquidator, a trustee in bankruptcy, a public officer or public body, a scheduled person, a solicitor or foreign lawyer, a certified public accountant practicing, a financial institution or designated non-financial business and profession, that is the DNFBP. And a scheduled person means a person that is specified in the schedule to CAP 622N, which include an inspector under the company's ordinance, an inspector appointed under the trustee ordinance, a recognized clearinghouse, recognized exchange company, recognized exchange controller, recognized investor compensation company as defined in the Securities and Futures Ordinance, CAP 571. And lastly, a person directed or appointed to investigate any matter under Section 11, subsection 1 of the Anti-Money Laundering and Counter-Terrorist Financing Ordinance, that is the AMLO. According to Section 12, subsection 6 to 12 of CAP 622N, except a data subject, person authorized by the data subject, and a member of the company, other specified persons are required to make a statement confirming that the protected information is required for the purpose of the performance of their functions and would be used only for that purpose. Financial institutions other than authorized institutions and DNFBPs under the AMLO are required to confirm that the protected information will only be used for the performance of their functions conferred or imposed on them under the AMLO. Regarding the application fee, a solicitor, foreign lawyer, CPA practicing, financial institution, and DNFBP are required to pay a fee of $10 for each data subject. Other types of specified person are exempted from the fee. My colleague Terence will explain in more detail about an application for disclosure of protected information later on in this seminar. To facilitate implementation of Phase 2 of the new inspection regime, we have amended some of the specified forms. The major changes involve revising the relevant parts for the reporting of correspondence addresses of directors and partial IDNs of individuals. A separate sheet, which we call a PI sheet, is added to each form for reporting of the protected information. This PI sheet will not be made available on the company's register for public inspection, and only specified persons may apply for disclosure of protected information contained in the PI sheets. According to Sections 3 and 4 of Schedule 6 of the CO, we have also revised the annual return that is required to be filed by a company each year. For local companies, that is Form AR1, the particulars to be contained in the annual return will no longer include the URA and full IDN of a natural person director and the full IDN of a natural person company secretary. For registered non-Hong Kong companies, that is Form NN3, the particulars to be contained in the annual return will no longer include the URA and full IDN of a natural person director, full IDN of a natural person company secretary, or a natural person authorized representative. For details, you may refer to Section 9, subsections 2A, 2B, and 2C of the company's non-Hong Kong companies regulation, Cap 622J. Regarding revision of specified forms and filing requirements, my colleague Philip will explain in more detail in the next session. In the next 5 minutes or so, I will briefly explain what a company should do upon commencement of Phase 2 of the new inspection regime. For local companies, the company should ensure that its register of directors will contain the correspondence address of all natural person directors. The correspondence address should be entered in the register of directors before the first annual return date of the company after the 24th of October. According to Section 641, subsections 2 and 7, a failure to comply with this requirement is an offense. The company and each of its responsible person is liable to a fine at level 4, that is $25,000, and a further fine of $700 per day if it is a continuing offense. Also, according to Section 115A, subsection 7 of Schedule 11 to the CO, a company does not need to deliver to the registrar a Form ND2B, that is a notice of change in particulars of company secretary and director, in the following 3 situations for compliance with Section 645, subsection 4 of the CO. Firstly, the company enters a correspondence address of a natural person director before the 24th of October. Secondly, the company makes any change to a natural person director's correspondence address contained in its register of directors before the 24th of October. And thirdly, the address of the company's registered office is being regarded as the correspondence address of a natural person director under Section 115A, subsection 6 of Schedule 11. However, if before the 24th of October, a company's register of directors contained the correspondence address of a natural person director, and that address is not the address of the company's registered office, then the company must register a Form ND2B in relation to the correspondence address within 15 days after the commencement of Phase 2. Regarding a registered non-Hong Kong company, if the company is registered before the 24th of October, the registrar will record the address of the company's principal place of business in Hong Kong as the correspondence address of its natural person director. Afterwards, the registrar will update such correspondence address with the latest address of the company's principal place of business in Hong Kong, contained in subsequent Form NN9, that is a return of change of address of a registered non-Hong Kong company, unless a Form NN7 for a change of the director's correspondence address is registered. Therefore, if a director would like to use an address other than the address of the company's principal place of business in Hong Kong as his correspondence address, then a Form NN7 should be filed to report the correspondence address of the director. This ends my part of the presentation. Thank you very much.